So the next session is entitled The Panama Papers, 1 year later. What impact has it had on offshore financial centers and their foreign clients? We have among the speakers Will Fitzgibbon of the ICIJ, which recently won a Pulitzer Prize for its work on the Panama Papers.
Congratulations. I should have said that straight away.
Eryn Schornick of Global Witness, and Dawn Smith of the BVI Financial Services Commission.
Okay, thank you very much. It falls to me to begin. Now, what is there to say 1 year on after Panama Papers? My editor, Jared Ryle, was here this time last year, and at this time last year, Panama Papers would have been, I suppose, a month or so old. What I'm going to do today, therefore, briefly, is fill in somewhat in an overview form what's happened that ICIJ and our partners are aware of in the last 12 months globally. So I want to provide a few examples of impacts that we see at a personal level, at a corporate level, at an international level. And then I also want to briefly turn to what the Panama Papers, both within the documents and outside the documents, tell us about the long-term impacts of this project and other offshore projects on reform and the future of the offshore industry. This map behind me was a map of impacts that ICIJ and our 400 media partners prepared in October last year. We gathered this on the basis of countries and jurisdictions who made responses or announced responses of some form to the Panama Papers. That included parliamentary inquiries, police raids, private sector audits such as that happened inside the Nordea Bank in Scandinavia, as well as certain jurisdictions and ministers who promised to look into Panama Papers, but about whom or about which never a peep was heard subsequently. So this map here gives you an overview of where Panama Papers had an official impact or reaction. Also next to it you can see what is almost certainly a lowball figure of individuals and companies who, again, according to media reports and interviews with officials by ICIJ journalists, of individuals and companies under audit or investigation as a result of the Panama Papers investigations. As of October last year, we'd estimated that conservatively to be around 6,500. I'm sure that's since expanded, and perhaps some of you in the audience will have some figures that they can share with us once we get to the questions. In terms of impacts, however, I also wanted to draw our attention to a few other impacts that perhaps don't come onto our radar so often. If we're honest with ourselves in this room, and there might be some exceptions, we probably don't regularly consult news that's coming out of Mongolia or Costa Rica. If we did though, however, we'd realise or have learnt that a parliamentary inquiry in Costa Rica just last month found that there were over 130 Costa Ricans within the Panama Papers. According to the Parliamentary Assembly that did the investigation, those Costa Ricans were using the services of the law firm Mossack Fonseca to hide profits and evade taxes. The picture behind me comes from a protest that took place in Ulaanbaatar in Mongolia about a month or two ago. Recently, the Mongolian parliament passed a bill that limited the rights of elected public officials in Mongolia to use and hold offshore companies. Moving away from those cases, it's worth, I think, reiterating that in places like Iceland, there were, as of last year, more than 100 tax cases under review for at least 46 cases of potential tax evasion. British authorities have been quite vocal and helpfully, at least from a journalistic perspective, helpfully public about the work that they're doing as a result of Panama Papers, with both civil and criminal investigations. Canada, France, India and Pakistan are also countries, and my own native Australia, where governments have provided public figures on the state of investigations and given either numbers of individuals or corporations under audit or investigation as a result of the leak and the project. And then also Europol, Europe's law enforcement agency, which revealed last year that it had matched the public Panama Papers data with its own data and found nearly 3,500 probable matches between Panama Papers files and its own information about organised crime, tax fraud, and other forms of criminality. Closer to home, in this room at least, behind me you'll see a letter attached to an email that ICIJ received 7 hours after Panama Papers was first published on the 3rd of April 2016. That's a fairly short email from the US Attorney's Office in the Southern District of New York asking for information. Unfortunately, that was the only correspondence we ever received from that office, and despite repeated follow-ups from ICIJ and other partners, we've never heard or been told what, if anything, has followed on from that particular request in the United States situation. I think it's also important as a journalist to recognise that the map that I showed earlier is not one where we think as journalists that there have been unmitigated successes and long-term impacts. Many of the results are mirages, for want of a better term. In Sierra Leone, for example, I remember the Ministry of Mines came out very quickly after Panama Papers and said it would investigate. It was never clear what they'd investigate, but it promised to do something. We had a reporter call back the Ministry of Mines a few months after the publication, and the responsible minister said that he had no idea what the journalist was talking about when he asked for an update on the investigation. Something that I think has surprised many of us in Panama Papers, at least in the journalistic community, is the long tail that the findings have had so far. I think a few cases stand out for me in that regard. One would be Pakistan. Behind me you can see the epigraph of the lead dissenting judgment from the Supreme Court that was handed down on the 20th of April last month, in which this judge and one other judge were in a minority, holding that the Prime Minister, Sharif, could be removed from office over corruption allegations laid by the opposition. The majority decision, however, it was 3-2, was that there was no grounds on which to remove the Prime Minister. However, the court did say that there would be a follow-up investigative panel that would continue to look at allegations that relate to the Prime Minister's children and to London property. I think it's also fascinating to note that late last month, 2 prosecutors in Argentina finalised an investigation and decided that they would not pursue an investigation against current President Mauricio Macri relating to companies and assets that were found within the Panama Papers. However, there is now a further investigation relating either to non-disclosure breaches or even tax evasion that's been passed to another court. Malta is another country also in the news, and where there were even protests last week related to the Panama Papers, where information not published and not published by the Panama Papers reporting team so far, but nonetheless related to Mossack Fonseca, in which allegations have been made that the wife of the Prime Minister is the owner of an offshore company created by Mossack Fonseca. The Maltese Prime Minister's denied those allegations, but there is, as I understand it, a magistrate who is now currently looking into those allegations. This is the somewhat forlorn image of what used to be Mossack Fonseca's office in El Salvador. In an interesting case of timing, the lettering from Mossack Fonseca's office there was taken down in the hours after the Panama Papers stories first broke. The firm insisted it was part of a pre-arranged standard office move. El Salvadorian media were somewhat less convinced by that argument. But Mossack Fonseca, has obviously, and many of you will be aware of this, experienced its own turmoils. A number of their offices have been definitively shut. Others have moved locations and been harder to track down, at least for journalists. This is an excerpt from an audit that the state of Wyoming in the United States did into Mossack Fonseca's presence in that state. We heard on an earlier panel that the US is a tax haven par excellence in and of itself. Wyoming is widely believed to be one of those, and the Wyoming Secretary of State conducted an audit into Mossack Fonseca's office there, found what it called egregious failures, and then slapped it with what doesn't seem like such an egregious $9,600 fine. Of course, Mossack Fonseca remains active. You'll be aware that the founders were recently released from months in detention. This is a letter written by Jürgen Mossack from his detention on the anniversary of Panama Papers, so it's not just journalists and us at this conference who celebrate it, or mark the occasion at least. The two founders have since been granted bail in relation to charges that relate to the Lavajato investigation and not to Panama Papers explicitly, I should point out. There are, however, as we understand it, an additional Panamanian lawyer who's still in detention and the firm's former representative in Brazil, also in detention. I wanted to move, before I end, just to what Panama Papers tells us as journalists about the future of the offshore industry and what we see from the Panama Papers. I'll move to something that Dawn might be interested or relieved to hear or have some thoughts on perhaps later. Panama Papers is full of at least 2 War and Peace length novels equivalents of meeting notes between Mossack Fonseca employees and clients who they deal business with. And there are often some quite frank exchanges there which, in addition to revealing wrongdoing, also reveal industry thoughts and reflections and predictions on what's happening in the offshore. There was an exchange, for example, about an Armageddon situation or scenario in the BVI following, I think, changes to the laws there in 2012, in which a client of Mossack Fonseca was saying that they were now no longer interested in creating BVI IBCs, offshore companies, and moving elsewhere. From the banal to the more scandalous, another way to hide the BO or the beneficial owner was a particularly colourful exchange, but also a revealing exchange, I think, in which, at least to me as a journalist, I was fascinated by the creativity and the flexibility of practitioners in this area, and that despite the fact that some jurisdictions are quite clearly becoming harder to do dirtier work in, such as the BVI, there always seemed to be an appetite among a certain percentage of Mossack Fonseca's clients to remain optimistic. And as I end on this note, I think there are 2 quotes that stick with me. One is that, and this came from, I think, a Swiss lawyer who was a client of Mossack Fonseca, who, yes, he lamented the fact that life had become harder for him, but he still sees a place for offshore structures, even in the future, but wearing a new set of clothes. And so as not to discourage too many of you in the room, or perhaps to facilitate further discussions, Mossack Fonseca once asked a client, I think this was in 2014, about the industry, and Mossack Fonseca itself mentioned that it was optimistic. Mossack Fonseca was optimistic and noted that the same symbol for crisis is the symbol for opportunity in Chinese, and that new and greater opportunities would continue to present themselves with more complex structures and accounting. And from a journalistic perspective, I would also imagine from a professional perspective involving many of you, that complex structures, complex accounting, the use of onshore, offshore jurisdictions, that is, clean jurisdictions that are increasingly taking on the clothing of the offshore world, such as New Zealand, Costa Rica, the Netherlands, Spain, and the United Kingdom, will be places where journalists will be looking and where perhaps you'll see future projects in the near future. And I'll pass now over to Eryn.
Thank you. I'll just wait a second for the slides to come up. All right, just while I start. My name is Eryn Schornick. I'm a policy advisor on the anti-money laundering team at Global Witness. Global Witness is an international advocacy organization And what we do is seek to expose and break the links between corruption, mostly natural resource-related corruption, conflict, human rights abuses, and environmental degradation. As we've done our work for about 21 years, we constantly came up against what we call anonymous companies. And so just to be clear, so that we're all on the same page, when I say anonymous company, I mean a company where it's nearly impossible to determine who the real life human being is that either derives economic benefit from that company or exercises control over that company. And that person, that human being, is what we call the beneficial owner. So today I was asked to speak a bit about the policy impacts since the Panama Papers first came out a year ago, and so I'll just try to give a bit of a global overview and then hone in a bit more here on the US because this is where we are, and I actually think that we have a huge problem here in the US. The Panama Papers gives a glimpse into the scale of Mossack Fonseca's operations and how it single-handedly created around 200,000 of these anonymous companies for their clients. What is interesting, as I mentioned previously, is that law enforcement usually calls or refers to this sort of Russian dolls effect as layering, where you have one company that owns another and another and another and so on and so forth, and what that does is effectively remove the actor from the bad actor, make further distance between that, so it's harder to determine who the bad actor is. And so we often hear about these companies being offshore, and BVI gets a bad rap, and all these other countries get a bad rap, but the real truth of the matter is that the U.S. incorporates around 2 million companies per year. No state in the United States collects beneficial ownership information, and we've had a real hard time in Congress getting any movement on this issue. What we found is that Mossack Fonseca was advertising Nevada and Wyoming actually as jurisdictions that were attractive for their clients to enjoy secrecy. I want to just point out, obviously, the creation of a company is not illegal. However, many of these anonymous companies are used because they can transact business like a person, buy property, move money, money that's ill-gotten. The anonymous companies may also be used to avoid taxes, evade taxes, and of course, carry out activity, anything around trafficking, human trafficking, weapons, diamonds, illegally gotten logs, humans, any of the other things that you think of when referring to trafficking. So what we did at Global Witness years before the Panama Papers is conceive of an idea of what it would look like for a person to go into an American law firm, in a place like New York City, and sort of say, I'd like to create one of these entities and perhaps do some layering or whatever it takes. And so what we did was create a storyline for an undercover investigator, and it was based off of the Theodore Obiang case, which some of you may be familiar with. It's the son of the president for life in Equatorial Guinea, a very resource-rich country, but this gentleman was able to steal upwards $300 million from his country, move it around the world. In California, he was able to buy a mansion and a private jet through his anonymously owned companies that his lawyers set up there. He bought luxury items around the world and also enjoyed Michael Jackson's famous sparkly glove. So we do a lot of investigations into the case back when it was more, there was more movement, and spent a lot of time reading about a sparkly glove. How did I go to law school to now read about sparkly gloves? What we did was, send this person in and hold themselves out to be a representative of a West African oil minister, and he wanted to move money to America without being detected. So we'll just show a short clip if you don't mind. No sound. supposed to have sound. Sure. I guess one thing I'll say is that this piece aired on 60 Minutes on January 31, and obviously we know that Panama Papers were released on April 3rd. So it was, particularly in the U.S., a real opportunity to continue to mount the pressure within Washington, particularly with Congress, which is something that we would need to pass some legislation that would require the disclosure of beneficial ownership information for all companies created here in America. The legislation that we are looking to advance is called the Incorporation Transparency and Law Enforcement Assistance Act. And what that act seeks to do is to require the collection of information on persons who create companies, their name, address, and information from a valid passport or driver's license. And the House and Senate bill, there's two complementary bills. They've been kicked around in Congress for about 9 years. The House bill, the only real difference between the two is that the House bill requires Treasury to collect the information if the state isn't already doing it, where the Senate bill requires the states to do it. So from our perspective, since they are so similar, we see pros and cons to both, but have really sort of found our way around that bill. Okay.
They don't send the lawyers to jail because we run the country.
Do you run the country?
Still do.
I love it.
Still do. I should say some lawyers run the country.
So you are some of them, 2 of them.
Yeah, a small amount. We're still members of a privileged class in this country.
So what does it mean you run the country? It means you...
We make the laws, and when we do so, we make them in a way that is advantageous to the lawyer. 2 ways. We make the laws, and some people say we selectively enforce the laws. Another way to look at it is the old adage, a good lawyer knows the law, and a great lawyer knows the judge. Okay. Now, in point of fact, I went to law school with half the judges who sit on the New York State Supreme and the Federal District Court in New York. This happens that way over time.
Right.
You have lunch with, you're members of the Bar Association. Are they going to throw a case for you? No. But are they going to bend over backwards to be courteous to you? Yes, they are.
If his name now would appear in connection with buying some real estate here and other items, it would look at least very, very embarrassing.
Right, because presumably his salary and wherever it is would not cover the kinds of acquisitions he's been
for sure, that's the salary of a teacher here. And so how can we make sure that he is being able to buy property here and to live a nice life, but his name being out?
Right.
So if you're buying in New York, you would probably want a New York LLC.
Any problems with setting it up? Who would own the LLC? So who is...
Presumably we would set up a little bit of a series of owners to try and, again, protect privacy as much as anything else.
Yeah.
So Company A is owned by Company B, which is owned jointly by Company C and D, and your party owns all of or the majority of the shares of C and D.
So we create several companies.
Yes. You'd probably be better off with a smaller bank. Because
that would be a possibility.
Because the bigger banks are much more serious about looking into that stuff.
Their reputation.
Right, yes.
And there may be other banking systems that are less rigorous on this than the U.S.
What would it be?
Number of possibilities. England has gotten recently very tough on this stuff too. The usual banking havens, I think, would be ones you would want to consider. We could provide you with the list of countries where the banking systems require less detail on ownership or source of funds.
You'd set up a Delaware corporation to own the real estate.
That's right. So
that's the same cost.
So you don't have to.
But what would be better, in Delaware or in New York?
Well, if you set it up in New York, you have an attorney general that has to review everything, and you have a state that has a big corporate tax department and everything else. You set it up in Delaware, that's where every corporation sets up. There's too many. The franchise tax is very small, and you don't get involved with big tax returns.
This ain't for me. My standards are higher.
But that's fair enough. It's good.
What?
Therefore, I said we have to be very frank. So
right.
Yeah.
That's not interesting.
Do you know anybody who would be able to do so?
I don't think so, and I wouldn't recommend it either.
Yeah.
Because those persons would be insulted.
So yeah, pressure was mounting. That had just aired on 60 Minutes. Panama Papers comes out, and all the while, James Cameron had just recently announced he was going to have a global summit on anti-corruption in the UK, and he was looking to hold it in May 2016. So what you had from there was a number of countries, I think it was about 46, come to the UK in May and make commitments about what they were going to do on this issue. What you saw was efforts by James Cameron and others to sort of use soft power to get overseas territories and crown dependencies to make similar commitments on disclosing beneficial ownership information, and it didn't quite go as far as some had hoped and as far as we had worked on, and obviously now James Cameron is no longer in office. However, before he left, the UK managed to implement its public registry. It's up and running now. 3 months after it was created, we did a data dive with 30 data scientists and looked into the pros and cons, the good and the bad of the registry, and we have been working with officials from the UK government to continue to improve that registry. One country, Ghana, has said, sure, we would like to do this. We want to make the information public, available to journalists, civil society, business, whomever is interested. However, we lack the resources technically and financially to move this forward. And so what they did was partner with what is now called Open Ownership. And I encourage you all to take a look online. It's just openownership.com. It's a platform where information that is being disclosed is aggregated on beneficial ownership around the world, and where companies can go and voluntarily disclose their ownership information. What we've seen since Norway's commitment is sort of somewhat of a backtrack on whether it will move forward with its registry, so time will tell what happens there. And France was one of the outliers who really took a step forward in a public registry commitment for trusts. However, just recently, their judiciary has put a bit of a stop to that. So we'll wait to see what happens. With regard to the EU, there's a fourth anti-money laundering directive, which requires all member states to collect beneficial ownership information. It's available to law enforcement, accountants, lawyers, those type of professionals. And it's available to those with a legitimate interest. We're not sure yet what exactly legitimate interest means, but presumably civil society journalists, those with a public interest, for example, would have access to that information. However, what we've seen a year after the Panama Papers is that a proposal was put forward, and it cites the Panama Papers directly, where they would like to review and I guess update the anti-money laundering directive, which would require all company registries to be public and for trusts that are administered in the EU to be registered, and for some information to be made public. So that's a really significant movement forward. I think that we'll see some definitive answer on whether those proposals are taken forward sometime mid this summer. These are some of the other proposals involved, but I think that's a result of some direct advocacy and impacts from the Panama Papers. I'm just going to straight up steal from Thomson Reuters because they did a really fantastic survey. They call it Informal Survey of Company Registries and Tax Offices in 230 jurisdictions where companies are incorporated. They called their findings overwhelmingly disappointing. So I'm not going to read the whole thing for you, but if you want to just take a look, I think what we've seen here is the margin of change no more than 5% in terms of the level of transparency that we've seen. And this is public information, so happy to help you find it if you're interested. Another thing is Thomson Reuters also provided this really interesting map where, as you'll see, the color coding, which with the dark colors being the most difficult jurisdictions to access information on companies, showing that there seems to be the most trouble in Africa and the Middle East. However, 1 year after, 8 new registries have been created, mostly in African countries except for 1. 3 countries have improved the availability of their information, again, all African countries, and only 1 online registry has gone cold, and that's Liberia. So something to be explored there about what's going on. As promised, I'll speak a little bit about advances or lack thereof here in the U.S. I think one that you all may be pretty familiar with is the geographical targeting orders, or otherwise known as GTOs, that the Treasury Department has come out with. The first one sought to require title insurance companies to identify the owners of LLCs that make all cash real estate purchases available, right? So originally it was only in Manhattan and Miami-Dade County, and it was for purchases of real estate over a certain threshold. What you see now is the jurisdictions where we are today, which this is now the 3rd iteration of the GTO, which was released in February 2017, so it should last until August 2017. And what the Treasury Department is seeking to do is to collect data in order to create a requirement that would better regulate the industry. Why that's happening is in 2001, the Patriot Act had a provision which required sellers of real estate to do anti-money laundering checks on their clients. Shortly thereafter, in 2002, there was a temporary exemption on this provision. We're now in 2017. The temporary exemption is still in place, somewhat troubling. The U.S. government did give this figure that 30% of the purchasers that were by people who have been subject of suspicious activity reports. So they're saying they're gathering some really good data, and that's why they continue to extend the GTO. In terms of, the continued pressure from the Panama Papers, the U.S. government under the Obama administration submitted a sort of, package of proposals for steps that it wanted to take, or rules they wanted to pass, which they did, or move forward, which they did, and just before the Anti-Corruption Summit in May of last year in the UK. And one of those things that they did was to finally issue this customer due diligence rule that had been kicking around for about 4 years. It was effective as of last summer, and it'll take 2 years for financial institutions to implement, whereby they must obtain the legal entity customers' beneficial ownership information. And so they're defining through the regulation beneficial owners as anyone having 25% or more stake in an entity and anyone with significant control over the entity. So while we were happy to see this, civil society and a number of others have had some concerns with this rule. The most troubling of which is that I could get 5 of my friends, hire somebody to be a nominee, director, or president, and we'll never get caught. The IMF had something to say about the control aspect of this definition. And a few other things that are concerning is that the person disclosing must only disclose to the best of their knowledge. And the other thing is that the financial institution must only verify that the beneficial owner is an actual person and not that it is actually the beneficial owner of the entity. And so just to sort of, I guess, skip over this one, but I did include it. The Obama administration, with that package, provided a proposal for legislation to Congress. To my knowledge, they were unable to find any champions or to move that forward. The definition within that proposal was the same as in the customer due diligence rule. I've already mentioned the Incorporation Transparency and Law Enforcement Assistance Act. It was introduced on February 3rd, a few days after the 60 Minutes piece aired. And so we'll look to continue to move that forward this year with our colleagues and champions in Congress. And then last but not least, I just wanted to highlight some of the supporters, because I think that what we've seen is a real sea change in the way in which Congress has looked at this issue. Previously, we'd go into meetings in the House and the Senate and just get like blank stares from staffers. Now, you sort of say Panama Papers, do you remember that? And they'll go, oh yeah, and then it becomes slightly more easy to talk about these issues. The bill is now bipartisan. In the Financial Service Committee, where the House bill sits, there was a task force to investigate terrorist financing, and that's within that time period that the task force was in place. They had 4 hearings, 3 of which involved the issue of beneficial ownership and the way in which it plays into this issue. That task force is now a subcommittee. The financial institutions, mainly the clearinghouse, which is, I'm sure you all know, the representatives of some of the largest and oldest banks in the United States, have come out in favor of the Incorporation Transparency and Law Enforcement Assistance Act, and they've actually called for the information to be made public, or at least available to them. The bills right now are silent as to whether the information is public. Finally, business leaders are also coming out in favor and demonstrating the use case and business case for this information. I encourage you to look at ownershiptransparency.com also for some case study examples and ways to get involved if that's interesting to you. And institutional investors representing $850 billion in assets under management have also called on Congress to advance this legislation for a number of reasons. I think the last thing I'll say is that all the while this has been going on and the pressure has been mounting and steps have been taken forward, unlike they have been previously in the U.S. and globally. The U.S. finished a FATF evaluation on its progress on AML in the U.S., and the FATF identified corporate secrecy as a main area of concern for the United States. So I'll leave it at that, and I appreciate your time. And if there's any questions, I'm more than happy.
Thank you, Eryn. Thank you, Will. Good morning. I still think it is everybody. I really wanted to be the first to wish you good afternoon, but Eryn finished up a little too early. The way I'm going to approach this today is essentially to talk about what's happening in the BVI now, what we've been doing over the past year since the Panama Papers. Then I'm going to talk about why I think we have been doing those things, and then end off by, sort of thinking about, well, where do we go from here? My name is Dawn Smith. I'm General Counsel at the Financial Services Commission in the British Virgin Islands, and for that sin, I get to be here. What are we doing in the BVI now? What have we been doing over the past year? Well, of course, there's been lots of investigations going on. We've been, whether it's from a regulatory perspective or a criminal perspective, we've been doing lots of compliance inspections, which the industry do not like. We've also been taking enforcement action. Again, that doesn't gain us many friends. We've also been responding to a lot of information requests, not only from the point of view of the Commission itself, which has its own set of MOUs and agreements, whether they're multilateral or bilateral, but also with respect to tax information exchange agreements. The International Tax Authority has been quite busy, the FIA has been busy, the Attorney General also receives a number of mutual legal assistance and other requests. FATCA is in operation, as are the common reporting standards. And those of you who know BVI will know that the litigation sector is always pretty busy. We've been working on the national risk assessment in preparation for the assessment coming up against the FATF standards. Service providers have been filing registers of directors at the corporate registry. Beneficial ownership information, they've been obtaining it from their introducer clients if they don't have it already. And the government has been putting together what is called the BOSS system, and I'll talk about that a little bit later on. You will also see, from a more general perspective, the government has been working very hard on its economic diversification agenda. Just recently, for example, as one example, the BVI Finance, which is the marketing arm of the financial services industry, has formally taken on a public-private sector ownership, and so they're taking things in a slightly different direction. An investment promotion agency has been established, and there has been a series of infrastructure improvements recently, such as the construction of a pair park, which extends a facility available for cruise tourism. We've been working on improving air access to the territory. The arbitration center, which is one of my pet projects, has been established. So we've been busy, and the question really is why? But I think another thing that you might be very interested to know, some people may be very happy to know, some people may be alarmed, is that incorporations have been falling. And you can see behind me there that they have actually been falling, I think, since 2012. So they've been going down, as have been the number of companies that are actually active on the register in the British Virgin Islands. And the question is, why has this been happening? Now, is this because of the Panama Papers? We know that the Panama Papers was in April 2016. I can't tell what role the the Panama Papers would have played, and we're going to talk about that some more. But certainly when you come to talking about what has been happening, when we're conducting investigations, it's been a long time now that the BVI has been in the business of trying to keep criminality out of its financial services industry. It's been in the business now a very long time of trying to remain on top of what the international standards are. And you can see that, because the Financial Investigation Agency has been around for some time, the regulator has been around for some time, the enforcement actions that has been taken, you can see from the statistics that we publish that those have been ongoing for some time. In terms of tax information exchange, the heyday for signing tax information exchange agreements was actually between 2008 and 2009, when the BVI signed 18 out of the 28 existing agreements, the first of which was signed as far back as 2002, I believe, with the United States. Mutual legal assistance in criminal matters as well as tax matters is something, again, that has been going on for some time. So I don't know that we can attribute those specifically to the Panama Papers. FATCA, we know when FATCA started, the Common Reporting Standards as well. Those have been, the facility to accommodate that has been in place in the BVI since the 1st of January last year, FATCA from 2014. The National Risk Assessment Exercise, which is quite comprehensive, actually started in 2014, 3 years ago. The Register of Directors Initiative became law, for argument's sake, let's say the 1st of January 2016, and the beneficial ownership information and the requirement to have that available and not just accessible from an introducer has been in place since the end of 2015. So people are busy because the deadlines for getting these things in have been, they're still ongoing and some of them are still live. Now, when it comes to the Beneficial Ownership Secure Search System, which we call BOSS, some of you will recall, it would have been last year, I believe, that the UK and the BVI signed an exchange of notes relating to access to beneficial ownership information for law enforcement agencies in the UK and the BVI. So the technology to accommodate that portal was presented to the industry in the BVI on the 1st of February this year. When it comes to BVI finance, again, in terms of diversifying, strengthening, and looking to the future with the financial services industry, both industry and the government have worked together to, I suppose, not just rebrand, but restructure and refocus the promotion of the BVI financial services industry. Investment promotion, I suppose we can all know what that means, but that was also, that agency was established in 2016. And we also have the infrastructure development that I was talking about, which seeks to capitalize on a lot of the momentum that has come about in the BVI, arising from the success of the financial services industry and also the tourism industry, which is our twin pillar. Now, has the Panama Papers had an impact? In one sense, I suppose it depends on why you were using BVI companies. There are some people who come up with different reasons. On the bad side, of course, you hear a lot about tax evasion and fraud and money laundering. On the other side, the defenders of the industry, and we certainly believe that the good operations far outweigh the bad, and I suppose time will tell. But people use BVI companies for a wide range of uses, including their business operations, real estate holding, and all those that you can see there, asset finance, listing vehicles, family and estate planning, and so on. So if we're thinking that the Panama Papers would prevent everybody who's bad from having anything to do with the BVI again, that would be a positive result. But I don't know that that will be the effect, or that it has been an effect, because as you can see from what I've just told you, is that there's a lot going on offshore. And 2016 for offshore, there was the Panama Papers, but there were also other things that were happening, and those equally could have had, certainly from the feedback that we have gotten, could have had an impact on our incorporations. So what was the impact directly, I can't say. I mean, there'll be people in this room who are in the industry who will have more direct contact with clients of the BVI than I would, because I do it from a regulatory perspective, and maybe you can tell me. Now, what can we say that it has done? And I think it's fair to say that it has provided information. And the question is, how are we going to use that information and what's the value of that information? I don't know, it's 2017, the access to information by a lot more people is a lot easier. It has certainly, I think, widened the participation in the debate about corporate transparency. From the perspective of a regulator, I know that this is not a new debate. And the debate continues. And where will the debate end? We're on that path right now, based on what I've been hearing Will and Eryn say. It's a fight that has been going on for a long time. It's not quite easy to take the ship in the direction everybody would want it to go to, because everybody has different interests. But certainly from my perspective, I'd be very keen to see where we eventually end up and what the final international standards are going to be. And I think the real question for us is, how has the world changed? Is the attitude of the world any different? When the BVI got into the business of incorporation, the world wasn't what it is now. The requirements are not the same. People did not have the same concern. And offshore, to my mind, like onshore, any other industry, is really a matter of supply and demand. And as long as, people are demanding something, somebody will supply it. And the question is, how do we control what people are, not that you would necessarily want to, but how do you make sure that what people are demanding is something that, everybody finds to be at an acceptable place? Now, what does this mean for offshore? I can only speak from the BVI experience. I can only speak to what we have always done and from the historical perspective. Certainly, I don't believe that there are many jurisdictions who fall into the rubric of offshore as it is used here are going to just pack up their industries and move off. These industries have been around for a long time. They are of significant importance to the quality of life, standard of living, and economic viability of these territories. So what do? And it's something that the BVI, for example, has always been doing, and I anticipate that we will continue to do, which is we will adopt, we will evolve, and we will remain relevant. And I think that's as much as I can say. Thank you very much.
A quick question. The BVI Financial Services Commission, I think, fined Mossack Fonseca in the region of $400,000,
yes,
something like that. Has the company paid that fine, and is it still operating in the BVI?
The company is still operating in the BVI, and they have paid it, or they're paying it. So there's not a question of it being outstanding, no.
So is it like in installments?
Well, I'm not sure about what the arrangements are, and I couldn't say. Yes, but there's no issue with Mossack and the payment of the fine. I think that's what I can definitively say.
Thanks.
My question's for Don. Dustin Delaney, I'm in Barbados, not too far from you. We use a lot of BVI companies in Barbados to hold property interests for domestic reasons in Barbados. One of the things that has been discussed, and I believe was mentioned last year, was whether the BVI would move towards a UBO registry that was publicly available. Has there been any further discussion on that?
What the BVI is doing now is BOSS, which is essentially the search portal that I've spoken about. As far as I know, there's nothing further. And that is a portal that's meant to access information from registered agents, which will be available between law enforcement in the BVI and to the United Kingdom.
Will there be any other access for for others, I guess, non-BVI registered agents and non-law enforcement?
I didn't get that question.
I was under the understanding, based upon what you just said, that the portal would be available to registered agents and law enforcement? Or would it be a publicly available portal?
No, the portal is, no, it's not publicly available. Yeah. The light is causing me a little bit of a problem.
Isn't a very important part of the problem of corporations offshore the question of responsibility by the directors for the actions of the corporation and the location of the books and records of the corporation? So why should there be an offshore jurisdiction that doesn't require directors to have fiduciary responsibility for what the corporation does? And why should it allow a corporation to exist without books and records in the jurisdiction of the corporation?
I'm not so sure what jurisdiction that would be that doesn't have directors to have responsibility for the actions of the company. I think that's a pretty standard provision, and that's certainly the case in the BVI. The second part of your question, I think you asked about books and records. Yes. And could you repeat that one, please?
The question I'm asking is, if you have a corporation, shouldn't there be books and records in the jurisdiction of the corporation? I mean, the country that incorporated the corporation. So if somebody incorporates in the BVI, shouldn't there be financial records in the BVI? And shouldn't there be some record of the meetings and actions of the board of directors in the BVI?
Oh, okay, I hear your question now. Whether it should or should not, I don't know if that's something that I can speak to. I know that people are required to have certain records in the BVI, such as the registers of directors and registers of members, and they're also supposed to be able to ascertain the financial situation of the company, and also if they're asked to produce books and records, they're supposed to produce them. I don't believe that there's a requirement for all the books and records to be in BVI. As to whether that should be the case, I don't have a view on it for obvious reasons. Please ask Will something. Or even Eryn.
I'll take a question even.
So within the map of places where people had taken action for the Panama Papers, there was the pretty classic cluster, Western Europe, as expected. However, Ukraine was not one of those nations where any action had been taken. Do you see any development, depending upon where the Poroshenko bloc goes in terms of political developments? Do you see any potential for further investigations if one oligarch happens to fall out of the bloc?
Based on my interactions with our Ukrainian media partners there, the main action that was taken was a press complaint against the TV partner, who alleged that, or complained rather, that by leading the story with the conflict in eastern Ukraine, which happened to coincide with the time that the president of Ukraine was active within or his representatives were active within the Panama Papers data, was somehow injurious to him and to the state of Ukraine. So, from my perspective, the reaction was more anti-media. The journalists who work there say that they don't hold out very much hope for the Panama Papers revelations to be taken any further.
In Ukraine, they have a public registry, actually, and their parliamentarians are very committed, and we've engaged with them quite a bit and learned from them and their sort of successes and challenges with that registry. I think many of the parliamentarians are quite young and looking to move forward, given what Will just said. So there's one side and another side.
Will?
Yes.
Over here. Are the records subpoenaable? I mean, has a court ordered the ICIJ to produce them to anyone, or has there been an application along those lines?
To my knowledge, there's been one application, but I'm not aware of either the background or the current status of that. So I wouldn't be able to speak to that any further, but I can certainly say that there's been no legal action taken against ICIJ as ICIJ since publication. Obviously, we're a network of 400 journalists, and if I'm speaking here today, it's as a representative of them, some of whom are in the room, by the way. So in different countries, there have been a number of legal actions that have either now ended or even currently in the courts in relation to Panama Papers publications. But with regard to ICIJ, no, not at this stage.
I'm not talking about the ICIJ being sued, but somebody wants access to the records to pursue a claim against somebody else, you know, whether there's a legal gateway for them to have access to that information.
So I think there has been one case within the United States, yes.
And they successfully obtained access to...
I don't know the answer to that.
Afternoon, Eryn. Is it possible that you can bring back up your graph that you stated that Reuters so beautifully put together?
Hit it, guys. I don't know. I don't have control over it. Apologies. Which graph? The one that the Thomson Reuters did?
Yeah, the map.
Yeah, I have it here, but I can't bring it up. Sorry.
Oh, unfortunate.
Ah, okay.
The map, I think it's probably 2 slides down.
Sorry? So there's that one in the map.
Yeah, the map. One more.
Is that what you were talking about?
No, that is a map of the world.
No, I think it's one that was a graph you're speaking of, right?
No, that is an actual map.
Offshore map, okay.
There we go.
Yeah, thank you.
Okay. A comment was made earlier, I'm not sure if you were in the session earlier, by Art, which talked about the states, that none of them required beneficial owners to be kept. And then there was also a discussion that the only jurisdiction in the world that is not signing up to CRS is the United States. And I noticed that the top left-hand corner of your map is beautifully shaded in a light color pink. I was wondering if that was by any chance an error, and that it should actually be dark purple as opposed to light purple.
I'm very glad you brought this up, and it's something I intend to discuss with my friends at Thomson Reuters, because
I did hear you mention that it was so beautifully put together by Reuters, so I thought by that you meant that you were in agreement with the graph.
I just borrowed it from them because I thought it was relatively accurate, but
Right.
I also took issue with that coloring as well, and so...
So in your estimation, the top left-hand corner of that map should actually be dark purple?
Should it be darker?
Yes, absolutely.
Oh, okay.
Sorry, I'm having trouble.
I just
hearing
wanted to get clarification on that point. Thank you
Yeah,
very much.
apologies. I just borrowed the map, and I thought it was a pretty good depiction, but absolutely, I think, as I indicated in my presentation, we've got quite an issue here.
Okay, we're going to break for lunch now, so could you please give the panel a round of applause?